USIBC members and guests. Thank you for joining our webinar today. This is a USIBC Rapid Response webinar. We're really pleased to have our media and entertainment knowledge partners at Nishith Desai Associates. For those of you that are not familiar with how the format of this type of interaction works, when there's a new policy or draft bill, in this case, that comes out, we ask our experts to come onto our platform, share a little bit of background so that we understand the nature of the legislation or the consultation, and then go in a little deeper so that we can understand the implications of that proposal on our businesses. And then, of course, we capture questions and comments so that USIBC can formally respond to the consultation as it develops. We're really pleased here today to have our team from Nishith Desai. They are our media and entertainment experts, and we always appreciate your insights. So I want to thank you and your team, Gauri. I'm going to hand the microphone over to you, but let me just share one more time that this webinar is on the record. It's being recorded. Let me ask that members stay off video, on mute. If you do have a question, please do raise your hand. We're happy to call on you, or likewise, you can put it into the chat. And later on, we will formally open it up to questions and answers. So with that, over to you, our colleagues at Nishith Desai Associates.
Thank you, Jay, and belated Happy Diwali to all. And interestingly, today I heard someone wishing even Merry Christmas in advance. So I think we are in between the two festivals. So season's greetings. Interestingly, we got, as Jay mentioned in his email, we got this as Diwali gift. In fact, Aparna and we were joking just 2 days before Diwali that we are likely to get some Diwali gift, and indeed we got one. When we look at some, sort of overarching regulations such as Broadcast Services Regulation Bill, one wonders, what is the sort of, what does it really do, right? Is it like changing something substantially? Is it only, a step forward only in some respects? Is it consolidating things? So we are trying to, going to address some of these questions. But before that, one would ask as to why there was a need, because sometimes people feel that if some things are going good, why things need to change, if at all. So this is not the first attempt, as some of us know, to bring something, on a overarching broadcasting bill. An attempt was made back in 1997, then 2001, a convergence bill and things like that. So this is yet another bill, in front of us. What is happening today, right? Let us see on the legislative side and also some court cases, that have been, ongoing in various matters, and the importance of those court cases and the impact of those court cases also sometimes leads to, legislative changes. So if you really see, from a broadcasting perspective, and when I say broadcasting, the definition is one to many. So, we'll come to that in a bit. But on the one hand, you had television and radio broadcasting, traditional mediums, being regulated through various, guidelines issued by MIB. The Cable Television Act was the only statutory legislation, that means parliamentary enacted legislation, and the rules thereunder were the only legislative piece, if you really see, that governed the broadcasting sector. Everything else was in the nature of guidelines issued by the Ministry of Information and Broadcasting, and you can see the list of those guidelines, in the act itself. So you have uplinking and downlinking guidelines, DTH, etc. So those guidelines, some of them apply to broadcasters, some of them apply to carriage. For example, DTH is a carriage, right? Similarly, you had FM guidelines. You have, as you know, within that also, the MIB controlled only some aspects such as licensing and content regulation, etc. On the other hand, you had regulator regulating the price, for example, right? The interconnection between the broadcasters and the carriage providers, the pricing at which it should happen, etc. Even if you see the license that is issued, it is not a legislation under the MIB, but it is the legislation which is the Telegraph Act, etc. Under those the licenses are issued, even the WPC license, etc. that gets issued. Those are not under any legislation, which is a broadcasting legislation, but it is a telecom legislation. I'm putting it, very simply here. So that is the background on the legislative side. What is happening on the development in the courts? So basically, especially on the news and entertainment side, I'm still talking about television aspect. The news and news related aspect, what happened is, insofar as regulation is concerned, the Bombay High Court in one of the media trial cases, the Bombay High Court said that there is a lacuna, in the law where the news broadcasters are not getting regulated appropriately, right? And thereafter, you had, self-regulation was working, but that was not effective enough. That was the observation put across, by the Bombay High Court. And then you had cable television rules being amended to include self-regulation under that, because as I said, thus far everything was working only under the guidelines, and so was the self-regulation, was not legislatively controlled mechanism, right? So I mean, I'm just giving you an overarching, view. Now suddenly in between, what happened is you had the OTT players coming in, and the question arose that who and how do we regulate? So MIB, of course, got the mandate to regulate, or I'm using the word regulation in a loose sense, but MIB got that mandate, and thereafter that MIB did not have a legislation under which any rules could be issued, right? So what happened is, because digital platforms were getting generally regulated under the Information Technology Act, you saw back in 2021, you had the media, the media industry, which sort of grew substantially in the OTT space, right? So then you had the intermediary guidelines being extended to even apply to the OTT platforms. And why am I saying all this? Because now you see OTT platforms now being regulated under this broadcasting bill also. So we will need to see that whether the part 3 of the intermediary guidelines, which regulated the OTT platforms, whereby they implemented the code of ethics, which is controlling your content, right? They had the self-regulatory mechanism, even in 3-tiered self-regulatory mechanism also implemented for the OTT platforms, right? You had a registration requirement, etc. So multiple things, got sort of made applicable to the OTT platforms. So you have this another piece sitting somewhere under the Information Technology Act, where MIB is the governing regulator or a ministry, right? So when and interestingly, now that particular code was challenged. The code of ethics and the rules were challenged before the Bombay High Court and the Chennai High Court. And Bombay High Court in the first instance said that the journalistic norms which are being applicable, you're extending them to the digital platforms where there is no legislative backing, etc. So they stayed rule 9, 1 and 3, where you had the self-regulatory mechanism, the code of ethics, etc. They said no, this is ultra vires the Information Technology Act. So obviously, when you have things being challenged, in the courts, you definitely need a backup plan, right? And that matter is pending before the Supreme Court now. So you need a backup plan. So what do we? And one additional development happened is recently MIB got the mandate for digital advertisements as well. So if you see the definition of program in the broadcasting bill, it includes advertisements as well, right? So with all these developments, now probably it is a good time to have one overarching legislation, which is a broadcasting bill. I would still comment that I don't like the word broadcasting for the OTT platforms because it is not one too many, and we'll discuss that. But let us say it is broadcasting and content, probably, on the digital platforms in one, legislation. There are, pros and cons, we'll discuss that. But now you have everything. Now the question arises, what happens to the guidelines which are sitting out there already issued? So you will see that this legislation is saying that we will grandfather, those initial guidelines that have been issued, and you can see that in some of the sections which Aparna will walk you through, right? So now the question is, how do we balance these things out? What is the impact of all of that? Are they simply consolidating the law? Are they adding something more? So let us deal with that one by one. So over to you, Aparna. First, why don't you explain with this background, what is really changing, if anything, when it comes to the what remains as it is, right? And what additional, if at all, has changed for the broadcasters. One caveat, however, the more we read this act, you will find more and more things, right? So I just want to put that caveat. Tomorrow we may think additional 5 points, because there are at least 20, 30, in the guideline form things sitting with MIB, right? Where each one has been amended, etc. And then you are reading that win the parent act to see where things have really changed, if at all, or is it consolidation. So we have made that attempt. We have sort of, done that mapping. So with that, we are giving our initial, as Jay says, rapid response to the proposed law. So over to you, Aparna, with that caveat.
Sure, thanks, Gauri. And I think one more thing, not sure, Gauri, if you mentioned, is that the drafting of this law is not the best. So one more caveat from our side would be that we've tried our best to interpret what the law, what the intent is behind some of the provisions, but the drafting remains a little questionable in this draft at least. So that's at least one aspect where I think there will be a lot of feedback that will be given to the government on clarity on some of the provisions. But let me start with answering your question on what remains applicable, right? So section 44 of the bill basically clarifies that all of the existing it lists several existing guidelines which will remain applicable even after the new law comes in, right? So I'll tell you which ones it talks about. So the DTH guidelines, the HITS guidelines, even the policy guidelines for uplinking, downlinking, that the new guidelines that came out last year, and several other guidelines under which the basically the existing framework that we had for all of these operators continues to exist. Now, while this continues to exist, what the law says is that so if there's penalty provisions in any of these existing guidelines, those also will remain applicable. But the section 44 also clarifies that while those existing penalty provisions remain applicable, if there is any inconsistency in terms of the penalty that is being imposed under those guidelines and the new law, the bill which will, once it becomes law, so which also lists down the penalty provisions, if there is inconsistency between how it's been dealt with in those existing guidelines and this new law, the new law is going to be applicable. In terms of penalties, I just want to bring out, what are the differences in relation to how it was earlier dealt with and how it is going to be dealt with now. So what they've done in relation to penalties is that they've given specific penalties in the schedules to the bill in relation to contraventions relating to, say, advertising code, not complying with the advertising code, program code, or say other provisions of the law, and they've given maximum penalty. Now, with the maximum penalty, what they've said is they've created different categories of operators. So they've separated operators in categories micro, small, medium, and major. And how do you determine if someone is falling between in the category micro, small, medium, or major? This will be determined on the basis of the turnover. Now, depending on which category you fall under, your penalty that may be imposed on you will be dependent on the type of the category you're falling in. For instance, it says that in relation to medium category of entities or persons, the maximum penalty, the penalty that can be imposed is 50% of the maximum penalty that's provided under the schedule. So this is something new, because earlier there is in any of the guidelines, there is no difference in terms of how the basis the turnover of a company. So that's something that will change. The other aspect is several of these earlier.
I think Jay has a question. I can see his raised hand. Maybe you want to take it now?
Yeah, no, I do. Thank you. Firstly, I'm going to ask Ashok Batra if you can come off video. Thank you, sir. But Aparna, my question for you is overall, are the penalties compared to existing penalties or in others, are they high? Are they getting higher, or are they lower, or are they fair? What's just a general sense? Does it feel like the penalties have increased and are harder, or are they fair and reasonable and kind of in comparison with where they were? Just best guess.
Yeah, so for some of them, it's fairly high. And what they've done is they've given penalty for first contravention and subsequent contravention if that happens within 3 years. So for instance, for some of them, and I can give you one example, say, not complying with the basically, yeah, so interfering with authorized telecommunication systems, the penalty is maximum penalty that they've given is 1,000 lakh rupees, which is quite high, right? I mean, what we've seen typically under existing guidelines is somewhere between say 50 crore and so on. So so this is definitely on the higher side, and obviously when it goes up to 3 subsequent contraventions, it becomes even higher. So it looks like in relation to some of the contraventions, there is a higher penalty. But if we see penalties in relation to, say, violation of program code, advertising code, that seems to be slightly on the lower side, because it is sort of up to, for the first contravention, up to maybe 1 lakh, or for some types of operators it's even 20,000. So it differs for different types of contraventions.
Thank you.
Right. So maybe I'll move on. And sorry, because I'm sharing my screen, I cannot see if anyone's raising their hand. So if Gauri or Jay, if you could let me know, that'll be helpful. Okay. So yeah, I think one more aspect that I was talking about is the appeal procedure. So under at least the DTH guidelines and the uplinking downlinking guidelines, there was no appeal provision. So in case there is a suspension or revocation that happens to your registration under these, or your permission that's been granted under these guidelines, there was no provision to go and appeal to an appellate body. So the only sort of recourse that you had would have been probably going in a writ petition, which we saw some time back in relation to one of the cases that happened that went up to the Supreme Court. But now there is an appeal procedure that's been provided under Section 10. So if there is a suspension or a revocation that happens, that the registering authority passes an order for such suspension or revocation, there is going to be an appellate authority, which is going to be right now it doesn't, the bill doesn't say who is the appellate authority, but it seems that they're going to be coming up with regulations, guidelines on that aspect as well, who and sort of constituting that appellate authority, or sort of appointing someone as the appellate authority under this law, and there's going to be an appeal procedure. One more aspect, and this is maybe not exactly related to traditional broadcasting operators, but there is a provision in relation to emerging technologies, and basically what it says is, in case the government feels at some point in the future that in relation to some emerging broadcasting technologies, they need to make the provisions of this act applicable, they can do so. And there's some parameters provided under the bill regarding what, basis what can the government decide if they can bring in these broadcasting services within the broadcasting technologies within the purview of this law. So Gauri, I think that's
sure.
A little bit on the.
So I think couple of concerns that we have is number one, when we say appellate authority, right? We have seen that sometimes the tribunal systems have not worked that effectively in India, and you saw government doing away with some of the tribunals and bringing back the court, like you saw in ITAB for the intellectual property cases, right? So we'll need to wait and watch as to what exactly the appellate authority they are talking about. Is it going to be TDSAT? Is it what exactly is going to happen? We'll need to wait and watch. And the act also talks about, grandfathering of the licenses. So suppose you have a DTH license, it is grandfathered under this law. However, they are also saying that you will need to, if something which is in addition to the existing law and under this act, then in that case you will be given time to comply for that, and then you will need to self-certify that you have done that compliance, and you will be given time for that. So that is why I said right in the beginning that each stakeholder, whether it be DTH, whether it be the broadcasters, the carriage providers, whether OTT, whoever, they will need to do proper mapping, of the compliances. And when I say compliances, it's not under only the act, but if there are additional rules that get issued, then that also we need to take that. We'll need to take that into account. My personal view is while they're grandfathering all the rules, it is going to be a little tedious, to figure out where, what exactly needs to be complied with. For example, the DTH, you have initial guidelines, then you have something called platform services related small, notification coming out, something more. So it is a good idea, for them while they're doing, they reissue some of the rules with more clarity. Wherever there is overlap, remove that overlap rather than just leaving it out there. If you're consolidating, please consolidate the rules as well. That should be our feedback to this bill. Now, once you have done, briefly on the broadcasting side, let us see what has happened to the OTT. Now, as I mentioned before, OTT are currently being regulated under the IT rules. Interestingly, if you see the provision that Aparna mentioned, where the grandfathering will happen for the existing rules, they do not mention the IT rules at all, right? So probably because it is under another legislation by another ministry, probably they will sort of repeal those part 3 of IT rules, and they may reissue a new set of rules for the OTT under the current regulation is what we believe. But let us understand, in the definitional context, the confusion that they have created. And because of that, we are not comfortable calling OTT as broadcasters. And why is something, Karishma, why don't you first deal with the definitional confusion, and then, we will see what, comparison between the current IT rules and what is sought to be done here under the broadcasting bill. Though I can see one hand going up, but I can't see who that is. Jay, do you want to take that question now or maybe
Absolutely.
later?
Thank you. Thank you, Gauri. We do have a question from Shobna. Please feel free to ask your question directly or come on screen, whatever you feel best. Over to you.
Thank you. Before we get into IT rules, and I understand that they've only repealed the Cable Television Regulation Act, and they've said that they will grandfather certain guidelines, as already pointed out in the Section 44. Is it fair to then assume that all the telecom TRAI regulations which pertain to tariff orders and interconnection and addressability will continue to remain, and that this broadcasting bill will only concern itself with the content aspect and regulate just the content aspect, and the carriage aspect will remain with TRAI and will continue to exist under the telecom regulation?
Yeah, unfortunately, that is the case. And that's why I said in the beginning, right? So this is only amounting to consolidation of what MIB has issued. Unfortunately, and this could have been a good opportunity to take, I don't know, I mean, there may be a mixed response to my comment on this, but I feel that there should be a single ministry because all the commercial aspects, right? MIB is the right ministry who's looking at the growth of the industry, right? And if the ministry which is looking at the growth of the industry, that may be the right ministry looking at the entire broadcasting piece holistically, rather than two different ministries looking at things differently. And that has been always the tussle, unfortunately. So this could have been a good opportunity because if you see the telecom bill, that version that came last time, the broadcasting services were tried to be pushed into that bill, and there was a lot of feedback on that. So now you have MIB trying to, bring out everything under this, under this law. But again, as you rightly said, the tariff and carriage and that piece is still missed out. That is still with, under the existing regime. this could have been a great opportunity to combine it. I mean, I'll just leave it at that.
Yeah, because I mean, I'm concerned that if that tariff aspect was to come under this, then OTT and terrestrial also could then your life would get complicated. So I don't know if
Yeah,
it's if it's good or
that's why I
bad.
said, correct. So there will be different perspectives to that. But you are right from a summary perspective. You are absolutely right. That piece continues as it. Over to you, Karish. You need to unmute yourself.
Thank you. Over to you, Gauri.
Am I audible?
Yeah, now you're
Oh.
audible. Go ahead. Yeah.
As Gauri was mentioning, the broadcasting, I can hear an echo. If can go on. As Gauri was mentioning, the broadcasting bill consolidates many fragmented policies in the broadcasting space. It also brings certain new things within its ambit, and one of the significant things that the bill has brought within its ambit is over-the-top broadcasting service. So, over-the-top broadcasting services have been over-the-top broadcasting services have been included within the definition of internet broadcasting networks. And as has already been pointed out, there are several definitional inconsistencies and circular aspects of many definitions. And one of the main definitions with which there are issues would be with respect to over-the-top broadcasting services. So as you can see the definition on the screen itself, OTT broadcasting service has been defined as a broadcasting service which is made available on demand or live to subscribers. And this initial aspect of the definition itself is inconsistent because, as you can see in the next slide, a broadcasting service is essentially described as one-to-many transmission of audio-visual or audiovisual programs. And the key aspect of this definition is that broadcasting is regarded as a one-to-many transmission. But then if you look at the definition of OTT broadcasting services, it's defined as a broadcasting service which is made available on demand. So the first two aspects of this itself are sort of inconsistent, where a one-to-many transmission of particular of content is being equated to services which are made available on demand. So that's the first issue with the definition. In fact, it would have been more appropriate to regulate OTT within this bill, but perhaps include it within in a separate chapter so as to not, it would be inappropriate to call it broadcasting in the technical sense, and would have made more sense to regulate it in a separate chapter and provide for all the obligations that apply under the bill in a separate chapter, say to digital programs, or just to not use the terminology broadcasting because it comes with many cons as well. Another important aspect of this definition is that the definition of OTT broadcasting services has a specific exclusion towards social media intermediaries or users of such intermediaries as defined under the intermediary guidelines. And I think the intention appears to be that these intermediaries should be regulated by the MIB under the IT rules, as Gauri had already mentioned. And another important aspect of the definition of OTT is that unlike how online curated content is defined under the intermediary guidelines, it's pretty content agnostic in the sense that it doesn't make a differentiation between news and current affairs as a form of content as opposed to the other content which is available on OTT platforms. So if you look at the definition of online curated content under the intermediary guidelines, it specifically calls out the kind of content and it draws a distinction between news and current affairs content, which is a separate kind of content. For example, documentaries are a specific kind of content which is under the definition of online curated content under the intermediary guidelines, but not under news. So there's clarity on under which definition documentaries would fall under, but under the bill, there's no such definitional, there's no such distinction in that sense. And perhaps the reason why under the intermediary guidelines there's a distinction is because there are different obligations that apply to publishers of news content and publishers of online curated content. Under this bill, in fact, it appears that there is a similar approach which is being taken. Under Section 20 of this bill, there's a separate dedicated provision to publish to persons who broadcast news and current affairs content. So it appears that while there is an exclusion for social media intermediaries and users of social media intermediaries, in the event there are persons who are broadcasting news content through such social media intermediaries, then it appears that the provisions of this of the bill, which includes compliance with the program code and the advertising code, those provisions appear to still be applicable. So it seems that while intermediaries are being removed from the general applicability of the bill, only with respect to news and current affairs content, especially, and there's a clarification that it's news which is being offered in a systematic business, professional, or commercial activity, then that the provisions of this bill would be applicable with respect to those broadcasters. And again, the just to clarify, the compliance requirements is on the person who is broadcasting this news, that is the account on the intermediary platform, and not on the intermediary itself. In fact, if you look at the definition of broadcasting services itself, there is a clarification which says that the entity or the person which is responsible for ensuring compliance with the requirements of this bill is on the operator who makes available the program, and not the network operator or the internet service provider. So it's essentially the person who is making available the content, which is in the context of OTT, who will be responsible for compliances with the bill. Um, Another important, definitional aspect which is which exists in the intermediary guidelines, but a similar provision which is not there in the bill, is that with respect to the intermediary guidelines are clarified that they apply to foreign companies to the extent that these foreign companies have systematic business activity of making their content available in India. But under the broadcasting bill, it's unclear whether if an OTT company does not have its operations in India, but it does not have its operations in India, whether it would apply or not. So specific clarifications in that regard would have been helpful. But
Aparna, could
generally,
you just go to that relevant slide? Sorry to interrupt. Yes.
yeah. Yeah. Um, and just as a general approach with respect to OTT platforms, it appears that MIB is taking a sort of light touch regulatory approach, and that they're not overly prescribing obligations, and it's less. They want to take a sort of less interfering sort of approach. In fact, the key obligation which is applicable towards OTT broadcasting services is what's mentioned in Part C of the bill, and Part C of the bill prescribes an intimation obligation on on internet broadcasting networks, and specifically for OTT broadcasting services. There is a requirement to intimate the MIB in case such OTT broadcasting services satisfies a particular threshold of subscribers or viewers. So, as opposed to the registration obligation of the licensing obligations applicable to other network operators, even under this bill, with respect to OTT broadcasting services, it appears to be just an intimation requirement. And this intimation requirement mirrors the existing intimation requirement under the intermediary guidelines, where publishers are required to intimate the MIB about the details of their entity and certain other information. But under the intermediary guidelines, there's no such threshold. It's applicable to all publishers. But under the broadcasting bill, this particular intimation requirement is also linked to a threshold. And so it seems that these two intimation requirements will now operate in parallel. And within Part C itself, there is a provision which states that the central government can, to prevent genuine hardship, can relax certain requirements which apply to OTT broadcasting services, in if they consider that it's expedient to do so. So I'll quickly just deal with the obligations that do apply to OTT broadcasting services, but just wanted to highlight that in the event the central government feels it's extremely harsh, then they can offer relaxations with respect to such compliances. One of the main obligations which will now apply to OTT broadcasting services, which Aparna will also deal with, is that they will now be required to comply with the advertising and programming code, which is mentioned in Section 19 of the Broadcasting Bill. The Advertising and Programming Code is something which already exists under the Cable Television Network Regulation Act, but she'll go into more detail with respect to what exactly it deals with. But just wanted to mention that the provision does state that different codes may be applicable to different network operators. So it is possible that OTT broadcasting services would be subject to a specific different code as opposed to, say, cable television network operators. And it's also it's even possible that even um, you know uh, news persons who broadcast news that is under Section 20, they could be subject to a separate code as well. So that's something which
Just
was
to, yeah, just to add here, you already have the ethics code, which is applicable to OTT platform providers. So ideal thing is, because for the others also, to cause less disruption, maybe they will adopt the same codes which are already applicable to all these stakeholders. I'm not going to use the word broadcasters, but probably they will just, extend the same codes which are existing under this bill. That is the ideal situation.
yeah. And other than the codes, which Aparna will also deal with, there are other obligations which are new in this act, which do not currently apply to OTT platforms in a strict sense. In the sense, there is an obligation under Section 21 for self-classification by broadcasters. So while there is an obligation of self-classification even under the intermediary guidelines, it appears that, and they fall under the similar factors as well, like for context, theme, tone, etc. But it's not clear exactly the nature, the whether the self classification would be in the nature of a rating system, or whether it would be like, or whether it would have like UA markers or anything like that. So that's still sort of a gray area. But self classification is another obligation. There is an obligation on the broadcast network operator to also put in place access control measures based on such classifications to restrict viewership based on the classification. But the access control measure is also an endeavor obligation, so it's not mandatory per se. Another important obligation is in relation to accessibility guidelines. So the MIB under Section 23 is empowered to issue accessibility guidelines to make sure that programs which are broadcasted on these networks will be accessible to persons with disabilities. And there is, under the Rights of Persons with Disabilities Act and the rules, there are accessibility guidelines which do apply to even information and communication technology, which currently, in fact, as recent as August 2023, they have been amended and they've been enforced as well. But it appears that the MIB is going to specifically issue these guidelines, and it appears to be in the nature of, say, requiring subtitling for content which is available on these platforms, or audio captions, or translating audio content to sign language, etc. So OTT platforms under this particular provision may be required to comply with these accessibility guidelines. And just quickly, just two additional small points is that under Section 4 of the bill, the government is also now empowered to regulate not just OTT services and not just broadcasting or broadcast network operators, but also services which are intricately connected to these broadcasters or broadcast network operators. So this, while there are no factors as to, or guidelines on what factors the government will consider in regulating these other service providers, but it could be possible that related service providers to OTTs, like content delivery networks, or service providers that offer analytics of data analytics or subscriber related analytics, could be covered within this. And lastly, another provision which used to be applicable only with respect to cable television operators and now is applicable to OTT as well is Section 6, which requires all broadcasters to compulsorily transmit certain channels. And these channels are in the nature of Doordarshan channels or channels related to Parliament. This is something that was a provision under the Cable Television Networks Act, but now it appears to be applicable to all broadcasters, so would also be applicable against OTT broadcasting services. Yeah, Gauri, if you wanted to specifically deal
Sure.
with linear channels
Sure,
offered by
sure.
the
So I think, today, as you can see, because now, OTT, the reason we call this out, because they are not bifurcating between the traditional broadcasters and OTT in several provisions of the bill. Though there may not be intention to make certain provisions applicable to OTT, the way it is being drafted, it appears that it may get applicable unless, as Karishma said, we have a separate chapter to bring in clarity what exactly is applicable to the OTT platforms. Just to give an example, before there has been a confusion, in terms of linear channels, right? So linear channels earlier, a lot of OTT platforms were carrying a linear channel on their platforms. In between, because of certain FDI related confusion, etc., some of them had stopped it. Later on, there was some letter issued by MIB to say that the decoders can be shared only with the licensed carriage providers and things like that. So there have been certain back and forth on this element, but the question will be that is there a real intention to make some of these provisions applicable to OTT? And that's the question we need to raise. We need to bring out these anomalies, and we need to point out that there may be unfortunate impact if you club everything together. Number two, I think when it comes to the news and current affairs, we just want to clarify what they have said is that even if I'm a systematic, provider of news and current affairs service on an intermediary platform, I'm still getting regulated. Now that is the same provision which is there today under the Information Technology Act. So as such things remain as it is, but I think they have been extra cautious in clarifying that. And as we will need to wait and watch on how the advertising and programming code come out. As I said before, now MIB can even control the digital advertisements. So we will need to wait and watch whether they, before the bill comes in, whether they already come out with some guidelines, or they will wait for the bill to become an act and then come out with some guidelines. But advertising is another piece we need to wait and watch to see how it will get regulated, whether under this bill or otherwise. Now I think let us quickly focus on Aparna will walk us through that CFC related provision, which is a little concerning for us, because if you really see that provision, yes, content evaluation committee. So today let us see what is the position today. Then Aparna will explain what is happening now. Today, yes, all the platforms, including OTT platforms, and so there are three buckets, right? When you have the broadcasters, they need to comply, of course, with their code. Then you have the OTT platforms, they need to comply with their code. Then you have carriage providers who are providing independent services, which are called platform services, right? Which even the current act has that definition of platform service. That means the carriage providers provide their own content on their platforms, which is not channel content, which is non-channel content. So they are responsible to comply, obviously, with their, they are liable for that particular code, right? But how to comply with that code? What is the mechanism to comply with that code? There is no micromanagement of that. Each company can take their own decision. How do they want to comply with it? Now let us see what the bill proposes to do, which we believe is micromanagement. It's over regulation. And Aparna, why don't you explain that? Though I can see one hand up. I can't figure out who that
I
is.
think Shimal has her hand up. Maybe we can
Yeah.
deal with that first.
Yes.
Thanks, Aparna. Thanks, Gauri. Just had a quick clarification. When you say that CDNs could be regulated, would that be CDNs that are only used by broadcasting services, or CDNs in general would get covered?
So if you see that provision, I mean, we are just giving as an example. We really don't know, right? Because the carriage is getting regulated, right? The carriage providers are regulated when in the internet context, it's a telecom operators who are providing the internet, they have their own license conditions, right? So we are also not clear as to what do they really mean that the service providers to the broadcasters or broadcasting network companies. So we just gave an example. We are not honestly, we are not clear what is the real intention behind that provision. So we will need to seek that clarity, because sometimes you have such open-ended sections, those scare me a lot, because that gives a lot of power in the hands of executive to do what they want. So we should, try to sort of push back on some of these open-ended provisions, or seek clarity. What exactly do you mean by, service providers to the broadcasting platforms? This was only an example. I don't think the act is saying anything around that. I thought I'll just clarify that.
Thank you. That's helpful.
Jay, do you also have a question? I think you also had your hand up.
No, I just wanted to make sure that we give ourselves a couple of minutes on the tail end so that we can
Yes.
have any overall questions, but also to plan sort of the next course of action. So back over to you.
Yeah. We are just 2-3 points away, so we can quickly close them. Because yeah, Aparna, over to you quickly on the, because this is an important element everybody is concerned about. So let's quickly deal with that, and then we can take additional questions. Yeah.
Yeah, so C, like Gauri said, it's a little problematic. What the law says is that this is to be constituted by every broadcaster or broadcasting network operator. So this will include OTT. And this committee needs to include members who are eminent individuals representing different social groups, and they've given some examples. And these ideally should be included, and this includes women, members of the scheduled caste and scheduled tribes, other minorities, etc. And what the provision says is that only programs that have been pre-certified by the CEC can be broadcast. So before any sort of content is put up, it will need to be sort of certified by the CEC, and the certificate issued by the CEC is to be displayed in the manner that's yet to be prescribed. So we don't know what that will be, but there will be a requirement to do that as well. Gauri, over to you.
Yeah, so I think, as I said, it in our mind, it is micromanagement. I want to reiterate that fact. And obviously, all of these companies, they do have very robust internal mechanism. Who should be in that mechanism, who should be left to their discretion into our mind. I think the next point is, of course, on the self-regulatory mechanism. I know we are sort of 10 minutes away, so nothing really changes. Because you already have a self-regulatory mechanism, as I said, for the broadcasters now, which got statutory backing, by the under the rules, cable television rules, and then you have OTT self-regulatory mechanism, which is already functioning. The question really arises is whether there will be multiple self-regulatory bodies for different stakeholders. There will be a single body. It will create confusion, because if you see the earlier rules, both the rules, they say there could be one or more such self-regulatory bodies, and that is the right thing to do in our mind, because if the codes are going to be different, for example, the content code and program code and the advertising code are going to be different for different stakeholders, then in our mind, even the self-regulatory body should be different, because the OTT, content, it's a full content. Traditionally, they have been given more leeway in terms of the nature of content they can carry. There are reasons behind that. There was a consultation process that was undertaken, after which that particular process has been set up. So if the intention of this law is simply to consolidate and maybe add some statutory teeth to some of the provisions which did not exist before, as pointed out by the court, then they should not touch the existing self-regulatory mechanism which is already in place. They do talk about grandfathering this existing mechanism under the cable rules, etc., but they have not talked about grandfathering the self-regulatory mechanism under the IT rules. Ideally, that should be the position, but unfortunately, they don't talk about it. Aparna, do you want to go to the next slide? Yeah, do you want to quickly take this?
Yeah, so the bill does provide several powers to the central government. A lot of this is similar to what is already there under the Cable TV Act, so I won't deal with it in too much detail. The only thing is now it also becomes applicable to OTT platforms, so that's why a lot of it is relevant. There are powers provided, powers to inspect any instruments being used by the operator, and the broad powers of inspection. For contravention of the program code or advertisement code, there are different powers that have been provided. So there's a power to require deletion, modification of content, providing an apology, and directing the channel to be off air for some time, and obviously imposing any penalties, right? In addition, there are other powers as well, which are slightly broad. The central government in some cases can also prohibit operation of any broadcasting service or any operator in certain areas of the country if they think that this is expedient to do in public interest. There is also the power to prohibit the transmission or retransmission of any program or television channel if necessary to, if they believe it's necessary to do so in the interest of sovereignty, security, and so on. And there is the power to regulate or prohibit transmission or retransmission of any program or channel. So a lot of this, even in the context of OTT, may already exist under the IT Act, but under this law also, since OTT will be regulated here as well, some of these provisions become relevant.
You're
Gauri,
on mute,
you're on
Gauri.
mute.
Yeah, so I think we are cognizant that there are only 8 minutes left. So first, let us take the questions, and if we want to sort of have some closing comments thereafter, we can take some of those. But I think from a next step perspective, I also want to share quick comments. I feel that the industry should do proper mapping, which we are also undertaking already. For each stakeholder, we have to map it. We have to identify the provisions which are appropriately overridden, not appropriately overridden, and request that the rules can't be simply grandfathered. They need to be revisited completely. What is applicable, what is not applicable, penalties, there should not be confusion. So all of that needs sanitization in my mind, before they say simply grandfathering. Maybe it can be a transitory provision, but in my mind, new rules should get reissued. Overall on the act, as Aparna said, unfortunately, extremely bad drafting creates a lot of confusion of the intention. And when it is bad drafting, as all of us know, it amounts to overarching higher discretionary power to the executive, which leads to again arbitrariness, right? So some of these things we will need to definitely push back. Maybe help the government to draft better. Create a separate chapter for OTT for sure, and have clarity on self-regulatory mechanism, that there should be separate self-regulatory mechanism for separate stakeholders, so that there is no confusion on in the manner in which the self-regulatory mechanism works. And I think I can see one hand up. But
Yeah.
as a summary, also I want to clarify that though 9th December is the deadline, I understand that several industry bodies, and so should USIBC, push back on the deadline because it has come right in the middle of the season. We should push back, ask for more time, and I'm sure all of us will request that through other industry bodies also. We are pushing back on the deadline. So with that, I will hand it back to Jay to take questions, and happy to continue this conversation. We have tried our level best to just summarize, but there is much more out there: infrastructure sharing, right of way, things like that. All that needs proper mapping.
Wonderful. Thank you. Well, first and foremost, we'll go to our question and answers, but super insightful for our members and guests. We will make these slides available to you. And so if we can get a copy of those, Gauri, we can pass them along. To immediately go to your question about asking for an extension, we will clearly do that. We will ask for 6 weeks or 2 months, just given the timing of the year. It's really hard to do over the holiday seasons, of course. John, over to you, sir. Thank you for your patience.
Yes, I was just coming to that. I think, Jay, I think unlike in the previous consultations, I think there are multiple guidelines that we need to look at. There are things that there are multiple legislations that we need to look at. One needs to also be familiar with the Telegraph Act and the carriage side of the regulations to be able to advise the government a way forward. And I think for that to do, for us to be able to do justice to that, I think we did at least 3 months. I know it's because we would want to give a good recommendation to MIB. So I think we should ask for at least 3 months. Just on, and I think I completely agree with all of the insights Gauri and team have presented to us today. I think one of the implications of the inclusion of OTT into broadcasting as well is that the government of India notified broadcasting as a telecommunication services in 2004, and therefore brought it under the TRAI Act. And therefore, if today OTT is categorized as broadcasting, then there is a high probability, and Gauri would be able to explain that to us, that the economic regulations, the interconnection regulations of TRAI could apply to the OTT and the internet broadcast. And also, I think one of the anomaly that the definition this has brought in is that OTT, it defines OTT network operator. And operators, as I understand from the definition, are those that manage and operate the network. As OTT, we don't operate or manage the network. And I think things like CDNs, I don't think they are a broadcast network. I think they just bring the content closer to the customers. And so I think there are a lot to comment and opine on, but just wanted to add that point on the 3 months, at least 3 months. And thank you so much.
So, John, you're absolutely right. Let me just quickly react. And honestly, I didn't want to sort of, get into that interconnection because that's going to be a very sore point. And that's exactly why we have been saying that there has to be a separate chapter. You call them, the same thing as IT services. Don't call them broadcasting, because the moment you call OTT as broadcasting, which is not the right thing, because they are not one to many. So many of these other other regulations that will get attracted, which is not the right thing from an overall industry perspective as well, right? So I mean, there will be different stakeholders may have different view on this, but if the intention is simply to consolidate, then that is not the that this should not create that further confusion for the OTT industry because of the definitional confusion. So I completely agree with you. The definitions need much more clarity, and so do the provisions. But yes, we will definitely be pointing that out.
Thank you. Thanks, John, for the question. Gokul, over to you, sir.
Thanks. So thank you, Gauri, Karishma, Aparna, for really a great briefing. So I've just 3 questions, actually. Most of them are clarifications. So one was, this is primarily around news entities. My question is, one, would this apply to content on other domains like the US or UK that is accessible in India? Because from your briefing, it seems like that's unclear as of now, unless I'm wrong. This next one is, would this also be applicable to news aggregators, or is that another area of clarification that we would need to seek? And lastly, when we say users in India, it will be great if we can have some specific, would it be rather registered users in India, or just services that are accessible via the web? Because that will infer some sort of targeting of the Indian market. Just some clarity around this would be great.
Sure, sure. So let me quickly take that. Let me start with your last question. You're absolutely right. Even if you see from a number of OTT users, forget the news for the time being, generally, right? If you see what they say, that you have registered users or viewers, right? So if it's a general website, right, where you have this content, it's very difficult to identify what do you mean by the number, that number. One day there may be 2,000 visitors, one day there may be 50,000 users, right? So that itself is a question mark as to how are they going to decide that threshold. And SSMI also had something similar, but at least there was some registration here. They some opening of the account. Here, as a user, I may simply be able to view the content without registering my account, right? So that itself is a question mark as to how they are going to actually look at. And I completely agree with you that when you say targeted activity and different legislations, if you see the data protection law, even the e-commerce rules under the Consumer Protection Act, they are identifying what do you mean by systematic business activity in India, right? There is some guidance being provided, which guidance is completely missing in this present law, unfortunately. In fact, you have a better guidance under the IT rules under Part 3 than in this law, right? So we completely agree on that. What was your first question, Vipul? Sorry, Vijay.
It was on the foreign content, like
yes,
domains
so
like
foreign,
US.
Yes, so there is no clarity. As I said, Rule 8 gives better clarity under the intermediary guidelines. There is no clarity how the foreign operators will be controlled under this, if at all. But ideally, if they adopt the same approach under the IT rules, that will be the ideal position in my mind.
And lastly, on news aggregators, is there any understanding there?
So there also there is no clarity because aggregation part of it is not clearly brought out in the definition at all. If you see section 20 also, it's simply the people who are providing the service, right? Whereas under the IT rules, they have specifically identified news aggregator definition. And I wonder whether we agree or not, but I wonder that why the same approach that they had, which they themselves have drafted, a few years back, why they could not simply adopt that under the present, act. By they have created more confusion with the new definitions and all of that under the present bill. So there is no clarity on news aggregators at all.
Great. Thank you. Thank you so much.
Shobna, you have a question. Back over to you, ma'am.
Hi, thanks, Jay. I wanted to just say that there are 3 or 4 things that, in addition to what John had said, I think in addition to what Gauri has said in terms of our approach for submission and the points that we need to bring out, I think there are 3 or 4 things that we need to also push back on. One is compulsory transmission of certain channels of Prasar Bharati, right? For OTT platforms. That really needs a significant pushback. Secondly, on accessibility, they have not carried forward one of the provisions that exists, which is about the 1% threshold of viewership, which exists currently, but I don't see mention of that in this bill. So we need to make sure that, at least that gets, if we can't get anything better, at least what we have now should be carried forward. Secondly, when it comes to CEC, it seems like every broadcaster will now have to have their own in-house CBFC, right? Now, of course, it's very onerous, as you've already said. But my question is, if we were to do something like that, then can we have a dispensation from having to go and apply and get a CBFC certificate for films as well? I mean, is that a thought? Do we want to do that, or just go back to them and say, look, CEC is just for every program on OTT or any other platform? I mean, really think again. And lastly, on penalties, I think generally we need to make a case for reduction of penalties. But, there is one provision which is very sort of strange, and it talks about how, the director or the CEO of the channel will have to make a public apology, which I find weird. I mean, I don't know what they want, and it's just, I don't know. It's probably something that needs to be struck out as well, I think.
Yeah, I mean, there are many more such, Shobna, as you're aware, we completely agree. I think this bill needs complete redrafting, if you ask me. I mean, honestly, there are so many of these inconsistencies and higher kind of thresholds that, we need to definitely push back on. So completely agree on all your points. We have taken, we have already noted all of these, but yes, on the CEO also, definitely we should push back because some of these provisions, they don't add much value in the ecosystem, right? So I think we should definitely make a case on your CBFC certificate. I think because it applies to only films and not your series content, though we can still try to negotiate in that manner, but since it is applicable only to films, I'm not sure whether it will sort of help. But I definitely we need to push back on that entire mechanism for sure.
Wonderful. Well, listen. As a follow up, I have one final question, but before doing that, I really want to thank Gauri and Karishma and Aparna for on your team. What you shared was super helpful. Might you be able to provide us a few kind of top level points that we can include in our draft? For those members or friends, what we typically do here at USIBC is we're going to clearly ask for an extension. But what we do is we gather an initial set of comments or inputs and then we mash it together, and then we share a draft with the members who then provide feedback. depending on the complexity or consensus, that may take multiple iterations to do that. And we provide typically a few days to a week in between. So at the tail end of a consultation like this, we may have gone through 7 or 8 or sometimes even a dozen different iterations. So if you do have any particular questions or concerns, share them with us. And then at the same time with our members in the coming days and weeks, we'll share a draft, an editable draft that you can then provide comments. But Gauri, I always find members, if there's something to respond to, it's much easier for them to get their arms around it. So if I could ask your team to maybe give us the top 10 issues, they don't, and then, you know, they don't have to be in necessarily legalese, but the 10 top issues, and then we can go into detail line by line response to the 50 or so, you know, provisions as needed, either favorable or provide commentary to enhance the rules. But I do have one final question I think really sets the stage for our entire response. Indian elections are coming up. In fact, state elections are even occurring, and we're anticipating shortly into the new year, national elections. Clearly, there's going to be some iterative process here in this bill. It's not quite ready for prime time, as you shared, and presumably there might be a round of drafts or two. What's your thinking? What have you heard about the real timeline for this bill and the likelihood that, you know, it's gonna, you know, move rather quickly or slowly? And I know reading the tea leaves is always difficult, but I would love to hear your insight on that question.
Sure. I think my gut feel is this will happen only after elections. You know, not before that, because this definitely needs a lot of work. Definitely not monsoon, we are not going there at all. And the budget session, if at all, you know, will be very short session just before the elections. So we believe that this will be post election. But my request to the members is that we prepare not only the feedback, but also draft some of the provisions out where we believe, for example, definitions, etc. So that work, in my mind, should continue, you know, between Jan, Feb, etc. Once the election in March, April, whenever they declare, you know, there obviously we may not, you know, sort of wait till then, but continue to work with the ministry next couple of months with appropriate drafting. Let's not only give feedback in terms of comments, because sometimes they get lost. If we give concrete drafted provisions, and work January, February, continue to work, then post elections we may have, you know, something coming up. So that's the timeline we are looking at.
For our members, I really want to thank everybody for your time. This was really a wonderful introduction to the bill. We talked a little bit about how we want to respond, the need for an extension, how we're going to do an iterative process, and I'll kind of end where we began. Gauri and team, thank you so much for being our media and entertainment knowledge partners. You really do justice to the term. This was incredibly insightful, useful, gave us, I think, a fair bit of background, not only what's in the bill, but why the ministry itself felt the need to kind of bring this forward. And I hope for our members that it helps you understand the context from which we're working with. And I want to thank everybody in advance as we develop a response to MIB and the broader Indian government, because clearly these issues are overlapping in other legislations and bills and guidelines. So thank you again. I will be in India at the Bangalore Tech Summit next week. Then for members, we're going to be doing a door knock in New Delhi. We invite you to join some of our government meetings. I'm sure MIB will be on the agenda, followed by the GPay Summit, where we're pleased to be working with the government on AI issues. So with that, have a good night, a good afternoon, or a good morning for those of you in the United States. And thank you again for your time.
Thank
Bye
you.
now.
Bye.